be in that. So we're going to get started, and as people join in, we'll look forward to seeing all of you during the course of the presentation. So welcome everybody. My name is Todd Wohl. I am with Braun International and Premier Estates International. I'm one of the partners, and our company sponsors and supports and has created the Fiduciary Education Forum and our website, specifically the fiduciaryforum.com website. And that is our Fiduciary Education Forum is purely educational events that we put on primarily via Zoom with professionals that and topics that we feel are kind of prescient for different types of clients that we work with. Because we work in so many different industries, we, from month to month have different types of presentations that are focused on, again, on topics that we're seeing that are, kind of urgent today. So I'm really pleased to have our speaker today, in addition to myself, is Matthew Bouslog. Matt, I hope I didn't mispronounce that. He is a partner at Allen Matkins. We've worked with Allen Matkins for 25 years. And our topic today is Article 9 foreclosures. How to use the sale process to protect your clients and understand the gray areas of the code requirement. And I can tell you it is a very hot topic, as we are doing many Article 9 sales right now. And the questions always tend to be the same, and we'll get into all those questions. So for those of you who don't really remember us, Braun International, we appraise, broker, and auction real estate and business assets throughout the U.S., Mexico, Caribbean, and England. And we focus on a lot of our services are in the distress world, receivership, bankruptcy, litigation workout. We're very strategic in what we do. There's really nobody like us, considering all the services that we have under our umbrellas. And we have become a specialist doing Article 9 foreclosures for the past, I don't know, about 15, maybe 18 years. So that's a little about us. Matt, why don't you introduce yourself, and then we'll get rolling.
Yeah. Hey, thanks. So I'm Matt Bouslog. I'm a partner at Allen Matkins. My practice and background is a mix between bankruptcy and restructuring and Article 9 work, which certainly has a relationship, but do debtor side, creditor side restructuring, but also Article 9 enforcement. A lot dealing with mezzanine loan foreclosures, representing mezzanine lenders. Advising them. I've been retained as an expert to advise on and give testimony on the adequacy of certain foreclosure procedures in connection with timeshare cases, and recently did a cannabis Article 9 foreclosure because you can't pull that into a bankruptcy court, and so end up dealing with a lot of different types of collateral. We're going to get into and focus largely on the public and private foreclosure sales. So if we can go ahead just one slide, this will give kind of an overview of the different choices and remedies that a secured creditor has under Article 9 and ways that you can enforce a lien either through judicial enforcement, collection rights, as I mentioned, private or public sale, or acceptance of collateral, often referred to as strict foreclosure. Again, today, I think the kind of primary focus is going to be on that public and private sale, but we'll address some of these other points briefly as well. So let's go ahead one more, please. So kind of the baseline here is that every aspect of a disposition of collateral, the method, the timing, the manner, the place, all of the terms have to be commercially reasonable, right? And so that's what it always comes down to. What is commercially reasonable? And that in the UCC is laid out in 9.627. That says what is commercially reasonable, and we'll get again more into those specifics. If you don't foreclose in a way that is commercially reasonable, then as a secured creditor, you can be liable for damages. It may not affect the validity of the sale. So you may be successful in the foreclosure, but still have a potential liability for damages, which can also impact any deficiency that you might have as a secured creditor and your attempt to pursue those deficiency claims, whether against the debtor, against some secondary obligor, some guarantor. So let's go ahead one more slide, please. So a 9627B lays out that a sale will be commercially reasonable if, and you've got three options here. 1 and 2 are somewhat similar, but in the usual manner on a recognized market, at the prices current in any recognized market. What does that mean, right? Typically, and it's kind of easiest just to think of publicly traded stock, something where there's a recognized market. And so for many types of collateral, and in particular the ones that I deal with in connection with real estate mezzanine loans, or enforcement of any kind of non-publicly traded equity interests, there's not going to be a recognized market. And so then this is where a lot of the focus and litigation is on this third prong. Was every aspect of it in conformity with the commercial reasonable practices among dealers and the type of collateral? And so that's where a lot of our focus is going to be today. And so let's go ahead one more. So the parties, and here we're going to get into, again, these points, these aspects apply to a public or a private sale, right? So right now we're talking about both of those. And it's not uncommon in certain loan transactions, and in particular in mezzanine loan agreements, and in the pledge agreement, that you might have an agreement between the parties on what is deemed to be commercially reasonable. And the UCC allows for this. And it says, hey, so long as it's not manifestly unreasonable, the parties can agree. And so what we have here is, a somewhat typical provision in a pledge agreement might include an acknowledgement that a foreclosure is commercially reasonable if it's conducted in New York and in accordance with the laws of New York, and the letter provides at least 10 days notice, or it might not even say at least, it just says no more than 12 and no less than 10 or something. The sale is conducted by an auctioneer in front of the Supreme Court located in the New York City, and notice is published in the New York Times or Wall Street Journal for 7 consecutive days, right? Sometimes then we've got clients that look at that and say, okay, so this is all I have to do, right? And the answer is, well, no, that might not be all you have to do. And there's a few reasons and issues with that. One is that in terms of the publication notice, for example, 7 consecutive days, that really may not be comprehensive. And therefore, a court might find that that's manifestly unreasonable. And to say that it's conducted in accordance with the laws of New York, I've had a New York court look at that and say, well, New York has its own UCC, Article 9, and therefore it's basically incorporating all of the body of New York law. And so it basically nullifies the whole point of this pre-agreement of what is commercially reasonable, because the judge decided that she then gets to import all of the applicable New York law to determine whether it's commercially reasonable. So that's kind of an out if a judge wants to look for it. As I mentioned, publishing 7 consecutive days in the New York Times, court may find that to be manifestly unreasonable. Sometimes it doesn't say New York Times or Wall Street Journal. Sometimes it just says Wall Street Journal. Well, you can't publish in the Wall Street Journal for 7 consecutive days because the Wall Street Journal doesn't publish every day. And there's also other potential ambiguity in terms of saying it's in front of the Supreme Court. Again, that's a New York's lowest court. But the way that that's written, I've had practitioners question and raise issues of, well, is that the actual courthouse? Or by saying it's before the New York court, does that mean that you're actually agreeing that it needs to be a judicial enforcement? And so having these types of provisions can raise sometimes more problems than you might think you're solving. So let's go one more.
Matt, is now a good time for me to talk about the commercially reasonableness from a sales standpoint, or do you want to move it through another slide?
I think let's go probably 2 more. where we'll get into the substance, right? This is kind of the setup. And yeah, I know Todd wants, he's got at least a case study or two, and I've got some as well. In terms of notice, again, this applies to a public or a private sale. And you've got to provide notice to all interested parties, interested persons, right? So that's the debtor, if there's multiple obligors, them as well, secondary obligors, guarantors, any other secured creditor, they might have a lien. And so, notice in both publication and actual notice, mailing the notification disposition in connection with the foreclosure, that's all critical, right? And so it has to be reasonable in terms of the way that it was sent and the timeliness. There is a safe harbor for notice to the debtor. Let's go back up one more.
Sorry.
So there's this safe harbor in the code that says that if you send it to the debtor 10 days before the time of the sale, then that's a safe harbor for notice. Sometimes folks think, oh, okay, well, so I can complete a foreclosure sale on 10 days notice. And the answer is not necessarily, right? That may be sufficient as far as notice is concerned, but may be insufficient insofar as the marketing and actual sale process, which again, we're going to get into just a little bit more. There's also a safe harbor in terms of running a UCC search to find out any other potential lien holders and notifying them. And so again, everything that we've talked to up to this point is all covering for a public or a private sale. And then now we're going to get into, okay, what are some of the specifics of a private sale? And so let's go ahead one. Yep. And so you might think, and in many bankruptcy cases, kind of the default and the fallback is kind of an assumed public sale process, right? That there's going to be overbidding. And the Article 9 actually has a policy encouraging private dispositions. There's an assumption baked in and a policy that a private disposition is most likely to achieve a higher realization than a public sale. And so sometimes I have clients concerned and confused about how they can sell something privately that they don't own. And that's the magic, I guess, of Article 9. It allows you to do just that. You can enter into a sale agreement with a party for an asset, even though you don't actually own that asset. But this doesn't work for in terms of the secured party actually purchasing the collateral, right? The secured party is not going to be able to credit bid and purchase the collateral itself unless it's, again, basically kind of publicly traded stock, right? Or it's something that's sold on a recognized market or with widely distributed standard price quotations. And in terms of widely distributed standard price quotations, there's commentary out there that, even though you might have a vehicle, for example, where you've got Kelley Blue Book and you've got other widely distributed kind of pricing guides, that's not widely distributed standard price quotations. And so a secured creditor, if it wants to be able to credit bid, would not be selling pursuant to a private sale, right? It would need to do a public sale, which we'll talk about. And in terms of notice, there's just kind of a point there at the bottom that only needs to be, you don't actually have to say for sure the date that the sale is going to occur in terms of the notification of the debtor. You can say, hey, look, the sale is going to occur no sooner than X date, right? And so that's kind of one little safe harbor. Give some flexibility to the secured creditor. So let's talk about the public sale now. And Todd, I think this would be a good spot on the next slide to jump into kind of some of the things that you want to talk about, and then we can incorporate some of this.
So, for some of you who aren't familiar with Article 9 and UCC sales that are on this presentation,
I didn't think anyone was in there. I couldn't see you from over there.
Oh, it's okay.
I think what's important to understand is the purpose of a public sale is to, whether you're foreclosing on real estate, or as you may have a loan, if your client has a loan on an asset, it could be real estate, it could be equipment, it could be inventory, it could be partnership interests, right, Matt? The loan could be pretty much on anything. But if the borrower is not performing, well, then there has to be this foreclosure process that must be put into place. So when we're contacted to come in and do to run a public sale, I think in this case we would like to use the word auction. I think is probably the most commonly word used for a public sale, not to confuse everybody. But an auction and engaging a company like ours is you're doing a couple things. You're engaging us as, and Matt, you can agree or disagree with me, but I say we're your insurance policy, right? We're the insurance policy that the sale process has been done in a commercially reasonable fashion. And in many cases, we kind of rub up against the grain of the secured because that secured may not want to invest a lot of money in running this type of sale. Would you agree, Matt?
Absolutely. So
our job as the insurance policy, or in this case, I would probably say the insurance company, is to create a sale process from start to finish that is what we deem and counsel for the secured, what we all deem is most and best commercially reasonable. And I will tell you that in most situations, we're doing two very large Article 9 sales, one upcoming that's about $85 million of real estate and partnership interest assets. This is a very big sale. And the common question is, how much do I need to spend? Or I should say it differently, Matt, how little do I need to spend in the form of advertising so we can do the sale, we're going to credit bid, and and so on. So my first question to the client is, do you intend for this sale process to find a public buyer, or do you intend for this sale process to cure your requirement, meaning you're going to credit bid? So those are the two questions that I start out with, and that then helps me gauge what we're trying to achieve at the outset, because that's a planning standpoint. So some form of advertisement or public notice must precede the sale. Well, this is again, as Matt said in previous pages here, this is where the rubber meets the road. So if we were auctioning, if the security interest was real estate, we would then have to create notices, advertisements, listings, marketing that would be specific to that real estate asset, be it, let's say a shopping center, an apartment building. And I'm not, we might list it on places such as LoopNet and CoStar or the multiple listing service. In addition to our websites, the e-blasts that we do, notifications into social media, there's a whole litany of marketing that we do to defend that sale, because if we are called in front of the judge and there is litigation, we have to defend what we felt was the right type of marketing, as Matt said, for that asset. That's very important. But I will tell you the kind of our rule of thumb, and we've never had it in any kind of court setting that we've been involved with, that the court the court did not agree with us that the Wall Street Journal National Edition, International Edition is not considered adequate notice. Now, that's the baseline, but we generally use the Wall Street Journal as a de facto print paper. But I will also say to you that that Wall Street Journal can be very expensive because you pay by the character, you pay by the line. So the notice that counsel provides to us, we then submit to the journal, and out they create a cost and tell us what it costs. Our biggest objection is we're spending, the client says, I don't want to spend that kind of money. So we have to find this balance as to what we feel is correct advertisement for that asset type. And again, it's multiple different types of advertising. But I think the other thing is, Matt alluded to this, is what is considered a commercially reasonable time of marketing. Matt, do you want to add into that before I kind of talk about that at all?
Yeah, and so I mean, when you talk about notice and the timing for the marketing, I've done this on a spectrum and based on the same kind of concerns and directions from clients, right? You've got cases where you may have a very litigious debtor, or secondary obligor, where you know that there's going to be a fight coming, right? You know, or you should expect that there's going to be a motion for a temporary restraining order or an injunction in some court somewhere to try to stop your foreclosure sale. And you've got to be prepared, right? And you've got to have your broker comfortable to be able to say, yeah, look, this is what's typically done, right? The asset is a real property asset in Texas, right? Simply doing an advertisement in the Wall Street Journal may not be enough, right?
Right.
You need to do some real estate publications in New York as well, but also some other real estate and or business publications in Texas. And even though the asset itself might be an equity interest, right? It's a mezz foreclosure, and so it's an equity interest in the entity that owns the property. The underlying asset is really the real estate, right, Todd? And so in terms of the marketing materials and the driving and everything else, yeah, it needs to be disclosed that this is an equity interest in an SPE that owns real estate. But the real interest and everything else is all about the real estate, right? What's the occupancy, right? What's the asset, the specs, everything else about the underlying asset is critical. And if we're dealing with, a very simple small commercial property, then that might be a different marketing process as compared to a $500 million office building in downtown Chicago, right? The length of time that you might have to market that may be different, again, based on kind of what the current circumstances are in the market and what your broker can comfortably say when challenged, and lay out and support that, yes, this was commercially reasonable because this is what other brokers in this situation typically do, right? They typically run a sale process of this amount of time in this way, sending out these kinds of blasts with that kind of publication, right? This is what brokers would do in this situation.
Right. So, I mean, that's well said, Matt. It really does this, and Matt, you're using the term broker. I really, even though we are brokers, I tend to look at really more the type of professional that you're engaging to run this sale. In most cases, be more of have an experience as an auction company, have an auction platform than I do as a brokered platform. I will tell you, of the hundreds of these that we've done over the years, I don't think ever I would have called it a brokered platform. I would call it an auction platform because the end result of the sale is an auction. So, and I also say this, an auction company has a very different mindset when it comes to marketing and exposure than a broker does. A broker generally has very little urgency in their life. An auction company is all about urgency because it's date certain. The sale is date certain. And as such, to create that frenzy, that bidding frenzy, right? You have to know and understand how to promote, advertise, and market. And that's an important, I think, definition for all of you when you're looking for a professional to run some sort of foreclosure sale. And again, going back to that timeline, there are sales, one we're working on right now, that might run 6 to 7 weeks of marketing. Because it is real estate and it's partnership interests that own real estate. So it's a complicated asset. It's a complicated set of underwriting, and we have to allow the buyers their time to underwrite, even though in this case the client feels that they could get it done in 3 weeks. And there's very little logic and to that because it won't get done that quickly. we're talking about $90 million of assets. So we try to blend all of these components to make sure that we have created the best insurance policy for Matt and his client. Regarding the notice itself, I think what I'd like to add, it must include the time and the place. Candidly, most of the sales we are doing now are via Zoom, just like this. And the courts have approved it. We did have a sale in New York a couple of years ago, and all the parties wanted it in the office of the law firm for the secured. And we forced people to actually come to that location. I have always argued that when you force somebody to be somewhere, you force them out of the market. And allowing them to participate via phone or via Zoom creates a bigger buyer pool. And that notice, I will say, is we require the attorney for the secured to draft that notice. We do not draft the notice. There's too much legal language, state by state, description, so that is provided to us by the counsel for the secured. Matt, you ready? Anything you want to add, or should I move on?
Yeah, so I want to hit a couple other points here. And the reason why we're spending so much time on this slide right here, right, is this is a public sale focus. And this is what most of what I end up dealing with end up being these public sales, because again, if you're dealing with some asset that's not some publicly traded something that's got, recognized price quotations and market, if the secured creditor wants the opportunity to bid, you've got to do it through a public sale. And so that's why, in most of these situations, you've got a secured creditor that, at least wants the right, or maybe it's the intent to credit bid, right? Maybe it acquired this debt with the express intent of then acquiring the assets, right? And so to be able to do that, you basically need to default to a public sale. And so that's why, again, I think we're focused so much here. There's a couple of cases that I want to note. These are California cases over the years. And again, this is the Uniform Commercial Code. So yes, it is, generally uniform throughout the country. Courts often approach these things in a very similar way. But, and candidly, most of what I end up doing involves New York, just given the kind of the mezz foreclosure aspect, and all of the documents are governed by New York law. Many times the assets are in New York, but they're not always.
Right.
But there's in some of these cases when they've looked at this, this is a quote from one of the cases that I think is instructive, right? This is where the foreclosure process was challenged, and the court said, the court does not know, for example, whether, given the nature of the collateral involved, a public auction at the steps of the city hall was reasonable, whether a sufficient number of bidders attended so as to make the auction worthwhile, whether it was reasonable to not sell the collateral through a private sale, or whether beginning the bidding at a certain amount was reasonable. What was absent in that case was any support, any evidentiary support. And so that's why, when these things are challenged, you need to be able to have and then provide the evidentiary support to defend the auction, right? And the court's not saying that none of those things were reasonable. It just says it doesn't have it, right? You need to be able to have somebody that can provide those facts. And when, we sometimes have a client coming to us wanting to do this without engaging, a third-party professional, an auction company to market and sell the assets, it creates a more vulnerable process. And I've done it that way. And I've done it that way where the client said, look, I'm going to take the risk, right? I'm not concerned. Meanwhile, I'm biting my nails the entire time throughout the process. And really, it only makes sense for certain types of assets where you might do that, or the dollar value is perhaps so low that it doesn't justify doing much more. But even in a case, where you've got any material value, anything that the client actually cares about, I think it's critical to be able to have that support. One other thing I want to note while we're still on this slide, there's not necessarily a uniform set of factors that I think courts consider in evaluating whether or not something's commercially reasonable. Again, you go to 9627B, which is in one of our earlier slides, you look to see what other parties and brokers would have done if this were not a foreclosure situation, right? How would somebody have sold this? But there's, at least one case here in California where a court went through 12 different factors, right? And kind of encompassed the whole gambit, right? And was considering, the extent and the manner in which the sale was advertised, the length of the time the sale was advertised, whether the sale was public or private, whether the collateral was repaired as needed before the sale. In that case, we was dealing with more personal property, not equity interests. Whether the prospective buyers had the opportunity to inspect the collateral, whether the sale was wholesale or retail, whether the collateral was sold in bulk or in parcels, which can make a
Yes.
difference if you're selling one or more, pieces of collateral. Whether the debtors and the guarantors were given adequate notice, the number and the amount of bids received, and the price achieved. Now, again, earlier 9627A of the Uniform Commercial Code specifically recognizes that the fact that a higher price could have been obtained does not in and of itself mean that it was not commercially reasonable, right? And so it's nice, it's beneficial that there's a policy kind of baked in, and that somebody can't come along and simply point out that you could have gotten a little bit more money, therefore this entire thing was not commercially reasonable. But you do still need to kind of make your own showing as the foreclosing creditor to show that it was done in a way that was commercially reasonable. So I think we can move on. So just a note here. Again, when I mention mezzanine loans, we'll get in a little bit more into how those are structured for anybody that may be unfamiliar with them. But when you're selling equity interests, and this doesn't just apply when it involves real estate, but you're selling equity interests, there's sometimes concerns that are raised. So, well, but under securities laws, am I even allowed to do this? And the SEC has issued no action letters that recognizes that yes, you can foreclose on these. There's certain protections, certain safeguards that have kind of generally recognized and accepted that under the private placement exception. And so long as you're not doing so long as you're selling the full equity interest to one party, and you have a number of kind of acknowledgments and other things that any prospective buyer would sign to participate in the auction, right? In terms Todd was mentioning, kind of the legalese that's incorporated into notices and other things. There's participation statements and other things that you want to make sure all the buyers are recognizing that you then can take advantage of these exemptions, that you don't end up creating other problems for yourself. Let's go one more. So this is just a sample timeline, right? This is not gospel, right? But sometimes you get clients where they're far down the track. Maybe they've engaged counsel, maybe they haven't, right? And they say, okay, well, how quickly can we foreclose on this thing, right? Again, it depends on the nature of the collateral. If it's perishable goods, then it would be unreasonable to conduct a 90-day marketing process. And you probably don't need to do a Wall Street Journal advertisements for some kind of perishable goods, right? But if you're talking about equity interests in something that's a big piece of real estate, then yeah, you may be looking at like roughly a 90-day process. Maybe it's a 60-day-ish marketing timeline. Again, it may be more depending on the nature and size of the piece of real estate. But that's why it's critical to have your professionals who can then weigh in on, yeah, look, this is what's happening in the market right now in terms of this type of real estate. It wouldn't be reasonable for us to do this in a 30-day process, right? Or for this piece of real estate, yeah, we can, right? Because it's a really hot market. If challenged, we could go to court. We could feel very comfortable defending this, right? And the attorneys are often not in a position to be able to make those calls. You need somebody with the kind of auction and broker expertise to fill that role. Let's go ahead one more.
Hold on one sec. For everybody who's paying attention to this slide, the bullet point that talks about published notices of sale and other advertisements. From my perspective, and we're not legal counsel in this situation. We're the advisors, as I like to say, to keep people out of harm's way. But in this situation, when we talk about notices, and Matt brought this up before, the Wall Street Journal, which to us is our kind of de facto most basic place to advertise, that runs 5 days a week in print form. Actually, pardon me, it runs 6 days a week in print form. But in digital form, it's daily. So most courts that we've been involved with look at print as the definition of advertising. They don't look at digital, at the internet as a form of advertising, even though we that's part of what we do in every sale. So the first thing we look at is what is the asset? So Matt talked about real estate, or a partnership interest that owns real estate, or an economic interest that owns an interest in an operating company or whatever. Well, there really isn't a place for that. There's not an industry specific place to advertise that type of asset. And we're dealing with this right now in this very large sale that we're going to market with. So we had to break it up, and I sense break it up because we had to look at part of it is real estate, part of it is an economic interest. So we said, well, the Wall Street Journal, nobody can argue that money doesn't read the journal. The world's money reads the journal. So if we were looking for a buyer who was looking for an economic interest or to make an alternative type of investment, the Wall Street Journal would be considered commercially reasonable. But at the same time, to Matt's point, because it's real estate, we want to be in the LoopNets, the CoStars, maybe even what we call the local multiple listing service. That might not be most relevant for certain types of real estate assets. Or let's say it was a widget manufacturing company, and they were the best widget manufacturers, and they had a trade publication. It was the National Association of Widget Manufacturers, right, Matt? So we would want to be in that periodical or in their digital advertising for the National Association of Widget Manufacturers. And that way we can very specifically pinpoint that that's the buyer pool that would be interested in the widgets, in the manufacturing company that makes the widgets. So again, it becomes very, very, very grassroots and nuanced to create the right type of marketing and promotion and advertising that we can defend for the actual process. And then really, as you see in Matt's timeline, the first bullet point is analyzing and underwriting, right? So that takes a lot of time. And we've had clients come to us and said, well, okay, today's Monday, we want to start the marketing on Friday. Well, we don't even know what it is we're selling. We don't have any of the security agreements. We don't have the financials. That all has to be put together, and that might take weeks. So again, it's a question of complication, but we try to look at every aspect of this, so it is the thought behind the action was very defensible. Anything you want to add, Matt, before we move on?
Yeah, let me say two things. One is going back to what I mentioned earlier, how sometimes in a pledge agreement you may have an acknowledgement that advertising in the New York Times or Wall Street Journal for 7 consecutive days is sufficient, right? A court may still find that's manifestly unreasonable if you've got, this widget maker, and everybody in this industry knows that if you're going to sell anything, you're going to do anything, it's going to be in that trade publication, right? If everybody knows that, it may be manifestly unreasonable to only advertise and publish notice and not to advertise in the national journals, Wall Street Journal or New York Times, but if that you then neglect to advertise in that trade journal. So I think that is critical. That's why you have to have a plan. That is why that's that first bullet. Second, there's a question here in the chat, and it's dealing with defaults under franchise agreements. And if you've got a franchisee that is defaulted, and the leasehold, the lease is tied to the franchisee maintaining its franchise agreement, how do lenders handle that? The reality is, I think it's going to depend on if you've got a franchisee that has multiple locations and it's a big, large loan, and you're strapped and there are concerns about whether or not you've got kind of full value there and you're perhaps undersecured as a lender, then an Article 9 sale may not make the most sense, right? That's where, and in the question, it was talking about how there was a bankruptcy 363 sale that was done. That may be a way to maximize the value, to kind of be able to sell the business as a going concern, because an Article 9 sale is not a sale of the business as a going concern. It's a sale of assets, and you're foreclosing on assets. And there's a lot of times in situations where an Article 9 sale makes a lot of sense. But the Todd talks about underwriting. The lender needs to be able to evaluate the collateral and determine, hey, is this the best approach, or do I need to push the debtor to run its own process, where we're going to do this through kind of a court supervised process. But if you don't have the debtor's participation, you don't have their consent, their involvement, that's going to make it even harder, right? And so you can push that Article 9 sale, but the debtor may flip it into a bankruptcy anyways, right? That sometimes happens. And maybe you early get relief from stay, and then you continue with the Article 9 sale outside of bankruptcy. So let's go ahead. We're going to move past public sales and private sales into strict foreclosure and some other things. But Todd, before we do that, is there anything else that you wanted to cover about kind of the public sale process?
One thing I want to add for those viewers who are more in the trust and estate side of the practice, because I see there are a few people here, Article 9 or UCC sales are used in your industry, for your purposes of gaining control of an asset that you may have a party, be a lender, your decedent, your trust, your estate may have assets that you don't have direct control of. And if you are not being paid, well, this is the way that you're going to approach that process to gain control of those assets. And we have done these types of sales for those purposes. And in many cases, they're generally real estate related or partnership interest related. But I don't have anything else here. I think I've covered everything. We'll move on to 11.
Okay, so we'll cover the strict foreclosure stuff. Again, this is not going to be as detailed perhaps, but what is strict foreclosure, right? A lot of people, you would analogize it, if you're more familiar with real estate, to accepting a deed in lieu.
Yes.
It involves a proposal by the lender to the debtor. There needs to be notice. There's an opportunity for an objection. There's an acceptance, and then you have a transfer statement. That transfer statement is, frankly, a lot of people just end up using something called a bill of sale. Article 9 doesn't contemplate a bill of sale; it contemplates a transfer statement. Even in connection with a public or private sale, you've got a transfer statement. And the debtor cannot force the lender to accept the collateral. The lender has to sign something as its proposal for the debtor to accept. Most of the strict foreclosures that I've been involved in have been a consensual arrangement between the secured lender and the debtor. But if there is an acceptance, then everybody's bound by the agreement. And if you fail to comply with something similar to the public and private sale, the strict foreclosure may be effective. So you may have then acquired the assets. You may just be subject to damages, right? So for example, if you didn't properly notice other parties, the foreclosure may still be effective, but you may be liable. Let's move ahead one. So there's two types of strict foreclosures. There's a full satisfaction and it's either full satisfaction and unconditional, or a partial satisfaction / conditional. And so if you are doing if you are accepting the collateral in full satisfaction unconditionally as a secured lender, then this is a situation where you can send a proposal to the debtor that lays out exactly that you're accepting, that your proposal is to accept the collateral unconditionally in full satisfaction of the debt. And then the debtor has 20 days to object. If the debtor does not object within that 20-day period, then it's done. So its acceptance can occur without the debtor actually affirming that and signing something. And similarly, from other parties that, other second junior lien holders on the property, they have to receive notice, have an opportunity to object. And if that happens, if you as the lender, you accept the collateral, pursuant to this proposal, it discharges the obligation, right? Makes sense. You're accepting it full satisfaction, transfers the debtor's rights of the collateral back to you, and it discharges or basically forecloses out any other junior liens on the property that on the collateral that's being foreclosed on. Let's compare that to a conditional or partial satisfaction. So let's go forward one. And so if it's conditional or it's partial, then the debtor in this case has to sign something, and they have to sign something after default, right? You can't in your loan documents have the debtor sign something that, oh, if I default, I'm deemed to transfer these back over to you. It doesn't work like that, right? It's got to be after default that they have to sign something acknowledging that they are transferring the collateral back to you based on certain conditions or only in satisfaction of a portion of the debt. And it effectively has the same outcome here in terms of discharging any junior interests in the property. But again, other parties, including junior lien holders, have to receive notice of the strict foreclosure. And it just like a full satisfaction, it transfers the collateral to the secured lender from the debtor. Let's go forward one. We're going to talk about the right of redemption. And this is kind of a critical point, and really, I think, what this all comes down to in terms of the debtor, protecting the debtor's rights, and other guarantors and lien holders. They have the right of redemption up until there's actually been a foreclosure, which would include, the secured lender entering into a contract to sell, which can happen either with a public or private sale. Up until that point, the debtor has a right of redemption. And in some states for real estate, the debtor has a right of redemption even after the foreclosure for some period of time. But again, under Article 9 for personal property, it's up until the foreclosure, and it has to tender, the full payment, right? Full payment of all the obligations that are outstanding on the loan, the fees and expenses in connection with the sale. And what the foreclosure does is it cuts off that right of redemption, right, at its core. So let's go forward again one, and we're going to talk a little bit about mezzanine collateral and then certain issues dealing with acquiring interests in a partnership or an LLC that actually owns, right? I've mentioned kind of throughout, I've mentioned mezzanine. This is a very common structure, at least in the real estate world, where you end up having foreclosures on UCC foreclosures on property, and this just lays out in kind of I guess maybe not the simplest terms, but what is a mezzanine borrower, right? Down at the very bottom you've got the property, up above you've got the owner of the property, right? A mortgage lender has a lien where it's on the property itself, right? It forecloses on the property either through a deed of trust or a mortgage, depending on the state. But a mezzanine loan, it has a pledge on the equity interest in that entity, right? That's the collateral. The collateral is the equity interest itself, and that's what's being foreclosed on. So when I talk about, mezz foreclosures or these issues that come up in connection with mezz foreclosures, it's not limited just to, an entity that actually owns property. This really implicates these issues anytime you have foreclosure on equity interests. It's just when you have an underlying piece of real estate, then it becomes extra important to then, include in your advertising, in your materials, and in the blast, all of the information about the underlying real estate as well. So let's go forward one. So when you're taking an equity interest in a when you take a lien on the equity interest in an entity, there's certain kind of legal issues here that we have in terms of Article 8, Article 9. There's nuances, and I'm not going to go through all of these things. But basically, this is all about, hey, you as a secured creditor, how do you ensure that you are the highest, most senior lien holder on this property, and that property is in fact certificated equity interests, LLC interest if it's an LLC, or membership interest, partnership interest if it's a limited partnership, and that you've actually got physical control of those certificates. That way you ensure that you have control over them and are perfected in them, and that nobody else has a lien senior to yours. If you don't do it that way, then there are possibilities that you think you're senior, and then the debtor ends up going out and granting a lien to somebody else. handing them physical certificates, and then they end up senior. There's certain protection, certain language that you need in the operating agreement and the certificates to make sure that those certificated interests actually do what you think they do, and that's some of what we have here. But let's go forward one. There's other issues that come up, again, very common in the mezz context, where if you're going to have a mezz loan, you very often have a mortgage loan down below. And so when those loan arrangements are entered into, you're typically going to have some kind of an inter-creditor agreement that's going to be crucial in governing the rights between that mezzanine lender and the mortgage lender. There's going to be typically some kind of like notice and standstill provisions that allow the mezzanine lender to exercise its foreclosure rights so that it's not having to battle with the mortgage lender coming in and foreclosing on the underlying property. If the mortgage lender forecloses on the underlying property, that cuts off any of the rights going upstream, right? It cuts off the owner's interest, and then by virtue of that would cut off the mezz lender's interest on the equity up above. But there may be restrictions, there may be conditions within that inter-creditor agreement. If you're not familiar with it, you need to find somebody that is familiar with them, because there may be restrictions on who can be a purchaser of that collateral. There may be requirements to have a replacement guarantor to come in and to backstop that mortgage debt. Again, there's certain time conditions. There may be abilities to extend out the mortgage loan by some amount of time and to cure defaults, if those defaults exist by the borrower, which probably do. They defaulted on your mezz loan, they probably defaulted on the mortgage loan. And if you as a mezz lender, if you don't want to have to write a check, for $100 million, $80 million, whatever, to take out that mortgage loan, then you want to make sure that you're preserving those rights under the inter-creditor agreement. Let's go to the next one. And this then is going to get into some of the issues and restrictions that pop up in connection with the equity interests, right? We can't just assume that, oh, yeah, I've got a lien on the equity interest, it's all good, right? I'm going to be able to foreclose on it, I'll step in, and then I'll own everything. There may be restrictions in the operating agreement, if it's an LLC, on assignments of membership interests, right. Or granting a lien on those membership interests, or admitting a third party as a transferee or as a member. There may be issues with the language that's used. I often see pledge agreements that say that it's granting a lien on the membership interest, right? Membership interest, quote unquote, is a term that's defined under California law. And so that's actually recognized. When you talk about an LLC agreement, membership interest is a term that's used in the California corporate code. That is not a defined term under Delaware law. So there may be issues. If you're foreclosing on quote unquote membership interests, somebody may raise an issue about what exactly does that even mean? What rights are you actually acquiring? There may be issues in the pledge agreement itself in terms of are you getting the economic rights only? Or do you get to step in and have all the rights as a member and the governance rights, right? Especially, again, if you're dealing with a situation where you've got multiple member LLC, are there consents and approvals from those other parties to the granting of the lien? Are they going to oppose you as the secured lender of coming in as a member to that? And so these issues can come up even if you don't have a multi-member LLC, but are even more likely to arise in those situations where you are stepping in and wanting to now become a partner with other parties. Yeah. So Article 9 has certain overrides that even if certain contracts prohibit granting a lien on certain property, Article 9 in some cases include overrides, right? And this applies not just to mezzanine loans, but maybe to other collateral, right? But it doesn't provide an override for everything. And if we're talking about a Delaware LLC, the Delaware UCC actually specifically defers to other Delaware codes and provisions to make clear that even though the UCC might allow you to take a lien on certain property, in fact, we're going to defer to corporate codes. And so what you thought was a lien, because the pledge agreement says you're getting a lien. In fact, if the underlying corporate governance documents say that you don't, then you may not have what you thought you have. And again, the UCC may defer to corporate code and the protections that the corporate code and provisions give to those members to not allow somebody else to come in.
One thing I want to add real quick, because I know we're
Please.
getting low on time. Operating agreements, people very rarely read them, take them as a grain of salt, put them away in a file, and don't even remember where they are. But those operating agreements are what we're bound by when we're brought in to sell. Obviously, same for Matt. Those, terms and conditions of sale, if there is a ROFR, right of first refusal, and how we deal with that through a sale process. And candidly, that might, because for some of you know that we actually sell partnership interests in real estate. We have a platform for it. First thing we look at is the operating agreement restrictions that exist there. So, or lack thereof. So that operating agreement is kind of for our better term, would say it's our Bible. And in the sale that we're working on right now, that operating agreement has certain restrictions that we're trying to deal with through the UCC sale and jump through those hoops. So you got to really pay attention. And candidly, you can't do this without counsel. I don't think I've ever done a UCC sale without counsel representing the secured. I mean, really, it's that important. I don't think we'd even take a sale on without working with an attorney who's representing the secured. So it's a little plug for you, Matt.
Yeah, appreciate it. And I mean, to piggyback off of that, especially if you're in a situation where you can expect some kind of fight from the debtor, you're having to give them advance notice, right? So they've got 60 days, perhaps, maybe more, maybe less, to prepare for that fight. And so you should expect in those situations, and it's not uncommon, to have a complaint and a motion for a TRO filed, the day before or 2 days before the foreclosure sale, right? And so, if you're expecting that, then I think you're negligent as on the secure creditor side if you're not preparing papers in advance, right? And a client may not love somebody spending time and a litigator drafting, documents in anticipation of that TRO that maybe doesn't come, but that's also part of the insurance policy, right? Because if you're able to get to it, beat back the request for a TRO, and have the foreclosure sale go through, right? You're good. You've made it through that hurdle, right? You may have other issues when it comes to trying to enforce deficiencies and claims against guarantor. But otherwise, if you're caught kind of behind the 8 ball and you're not able to properly defend against the TRO, good chance that might get entered, delays your sale. Maybe that's problems for you. Maybe it doesn't cause problems for you. Depends on kind of the nature of the collateral and the way things are going.
Let me add one thing to this, because I know we just have a couple of minutes. People ask me, what do these things cost? I'm not here to, I'm only speaking about our side. I'm not speaking about litigation, counsel, all those things. My answer is, how long is a piece of string? Well, nobody knows how long a piece of string is until you actually have the facts. So in the case that we're working on right now, $80 million sale, a $90 million sale, complicated partnership interest in real estate, complicated real estate. And, we know that there's going to be a fight. The marketing and advertising for this specific example would probably approach $50,000, $60,000. And if there is a TRO and there's a delay, well, then we may have to start up and do it again. And, the client's not happy, but it is what it is. So the advertising, it might be as low as $15,000. Again, it depends on what the asset is. And our fee is not generally based on a commission. It is a flat fee. And that's based upon, what we're doing, how we're doing at the time that we're doing it, and so on. And that might be as low as $10,000, and it may be as high as a couple $100,000. So again, it varies. And because there's so much unknown. So it's case by case. Matt, is there another slide you want to hit before we have 1 minute left? I want to make sure.
No,
that was it.
I think that's it, right? This just kind of wraps up in terms of restrictions under operating agreements, but I think we're good. I think we covered this. Yeah.
Does anybody have any questions that they want to unmute and just ask real quick before we're at the top of the hour, but Matt's information, if you want to speak with him directly, here is his email address, and phone number. This presentation will be on the fiduciaryforum.com website as well as this video. But please reach out to Matt and ask any questions you may, or to me as well. And we're happy to answer any questions or just strategize or whatever we can do. We really appreciate all of you being on. We hope you found this to be very informative. It's a very nuanced, specific industry and requires people that really know what they're doing. Even in the most simple asset, candidly, you can't cut corners. That's generally the way I approach it. Matt, anything in closing?
No, look, just my pleasure. Appreciate the opportunity to present with you, and would echo that and say if you've got questions, you want to bounce something around, certainly happy to chat, and feel free to reach out.
Okay, well, look, for everybody, thank you. We'll have our next Fiduciary Forum Education Forum presentation probably towards the end of March. Topic, it will be sent out, and please keep your eyes open on your emails. We send them via email, and we hope you enjoyed this presentation, and thank you all very much for participating. Matt, thank you very much as well, and
Thank you.
everybody be well.
Bye. Al.